Right. European requirements and FATF requirements have tended to march in step. When the Europeans implement FATF requirements, they tend to go a bit further than the actual recommendations. And then next time FATF are looking at their recommendations, they see what Europe's doing and think that's a good idea, we'll do all that and a bit more. So regional requirements do matter as well as national requirements. The states go a lot further on their requirements for banks, but they've not complied with any of the requirements for lawyers and accountants. They say they don't have to do anything because it's all covered by professional confidentiality. Though we think even the states are under pressure to become more compliant in this area. And I know that you in Australia are looking at it, and the government's now looking at bringing in something, I'm told, summer 2011 or sometime around that time. And, well, the Americans especially are rather into extraterritorial enforcement, and it's really embarrassing to get one of your national firms caught by the Americans. These are the FATF requirements that are relevant to lawyers and accountants. Lawyers, accountants and tax advisors, these are people in business as lawyers, accountants and tax advisors. It's not people who are employed in them. So it's practicing firms rather than individual accountants or lawyers in business, acting for a business. It's practicing people rather than commercial employees of organisations. And these are the gatekeeper functions, the ways in which a lawyer or accountant could obscure the ownership of money before it gets to a bank and the financial system. So it's operating a client money account or acting under a power of attorney for clients or as an executor under their will, or it's setting up trusts and companies where ownership is divorced from possession and beneficial ownership can be obscured. Other functions of lawyers and accountants aren't required to be within the AML system. And while you're carrying out those functions, you have a requirement to report money laundering suspicions to the appropriate authorities, in your case, AUSTRAC. Countries are recommended to also require, strongly encouraged it says, to extend the reporting requirement to all functions of accountants. This is because some functions of accountants, it's most apparent in audit, but actually in quite a lot of other functions of accountants as well. They may actually form suspicions of illegality, including money laundering in their clients. So this is why this has been included. But there are downside risks to this. And it's a matter for individual jurisdictions to decide whether they think that this is an appropriate extension for them or not. It's not really something to talk to me about. It's something to talk to the Australian CPAs and the Australian Institute of Chartered Accountants about. And you don't have to report a suspicion if it's covered by professional confidentiality or legal professional privilege. I've found that lawyers actually make very little distinction between legal professional privilege and professional confidentiality. They are different, though. Legal professional privilege is established by law, and it is an absolute requirement. The privilege belongs to the client, not to the professional. Professional confidentiality is much more something under professional expectations and requirements, and it can be a contractual obligation on lawyers and accountants, and it would be addressed by civil means.
Sorry, can I just...
Yeah, sure.
You say contractual. Do you also have views on it being a fiduciary obligation?
I always have a trouble with the word fiduciary. I never really know what it means. I think everybody has obligations to their client, and they are pretty much absolute, unless they are overtaken by some other public interest consideration. So it doesn't count as breaking client confidentiality to report something to the appropriate authorities, having made a public interest judgment that that is the appropriate thing to do. This is the position of my institute, the ICAEW. And we have had this position for about 20 years, more than 20 years now. And it seems right to me for most of the functions of accountants. But where you are reporting to the appropriate authority in the public interest, other than by the operation of law, other than being required to, it does require a careful professional judgment and a consideration of all the circumstances. As a lawyer's professional confidentiality acts differently, as I've said. They consider it to be an pretty well absolute. And there are some areas where your confidentiality would be pretty well absolute, when an accountant sometimes can actually be a more effective advocate for their clients than a lawyer in areas such as tax legislation, certainly in the UK, where accountants tend to know more about tax law than lawyers do. And so the balance of confidentiality would shift. Tax advisors in the UK, including accountants, were very, very upset when the shift of disclosure was avoided by the bringing in of a statutory instrument called the disclosure of tax avoidance schemes, DOTAS. The requirements for the disclosure of tax avoidance schemes, where tax advisors were required to inform the tax authorities when they began providing a new scheme for tax avoidance. That is a perfectly legal way of arranging your affairs in such a way that it minimized tax. And lawyers refused to sign up to this on the grounds of legal professional privilege. So this tilted the competitive field between tax advisors who are lawyers and tax advisors who are accountants strongly in favour of the lawyers, in spite of the fact that, as I've said, often it's accountants who have a better understanding of the tax law. So a competitive inequality built into the law, and we're very upset about it. We're trying to get full legal professional privilege for all tax advisors, but so far we're not getting very far with it. Our anti-money laundering law, this is just background really, is the definition of money laundering and the requirement for people in the regulated sector to make reports of money laundering suspicions, either internally or direct to the FIU, or in the Proceeds of Crime Act and the Terrorism Act. The money laundering regulations are systems requirements for firms: verification of identity of your clients, customary due diligence, record keeping, reporting for systems, and the identification of a single person within the organisation who has responsibility of remitting the suspicion reports onto SOCA. To have such an individual is important for quality control purposes. He reviews the possible suspicions to make sure that they're valid, reportable suspicions, and by having a single person making the reports, it means that they get used to filling in the standard form. And because banks are really, really different from professional firms and form their suspicions in different ways, it's filled out by industry guidance, which, having been through due process, is given Treasury approval, and Treasury approved guidance must be taken into account by the courts in judging whether firms have complied with the regulations and individuals have complied with their reporting obligations.